Hello everyone, and thank you for tuning in to today's webinar. We have a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please let us know in that same questions tool, and a member of our admin team will be on hand to support you. And finally, just to note, today's session is being recorded and we'll be sharing a copy with you all via email in the coming days. So, without further ado, I'd like to hand over to David to get us started.
Thank you so much, Jordan. It's always nice to connect with you on these. Welcome to our audience today. Welcome to our speaker, Fred Dawkins. We're so excited to have you presenting. And I just wanted to do a quick introduction here and tell you a little bit about HBL. Fred, if you'll advance the slide, please. We are a boutique ERISA and employment law firm. We're headquartered in Atlanta, Georgia. We also have an office in Philadelphia, Pennsylvania. And here's all the pertinent details as to how to follow us on social media. We produce a lot of content, this webinar being a great example. Please follow us on any of the socials that you see, Facebook, Twitter, LinkedIn. We have a YouTube channel where you can find past webinars, and I would also encourage you to visit our website, www.hallbenefitslaw.com, to see even more content, including daily blogs, articles that have been published, and press releases from the firm. But most importantly, again, is the idea that we are education for plan sponsors and for those employers out there who may need advice relative to employment law, that we want to be a resource for you. And that's why we're so excited to have Fred presenting today. If you do have questions outside of today's presentation, please send those to admin@hallbenefitslaw.com. You can also reach out directly via the number on the screen there to work with Fred. We can schedule a call with Fred if you have a specific employment matter, either related to EEOC or not. We'd be happy to help you out. And then to receive our monthly HR alerts, please do go to our website and sign up, and you will get a monthly newsletter. We won't be spamming you or calling you. We will simply be sending you content on a regular basis that we hope is helpful as you run your business and help to be a part of your organization. Great interest in today's webinar. So Fred, if you go ahead and kick it one more slide there, we're going to be talking about how to respond to EEOC charges. And as you know by now, Fred Dawkins is going to be your speaker. Let's go ahead and advance the slide. There you go. Fred is a trusted resource for HBL clients in the area of employment law. He's got just about 30 years of experience doing what he does, including first chair trial experience. So Fred is a litigator as well. And we're very excited and proud to say that he has been named a 2021 super lawyer. So without further ado, I think you will be very encouraged by and impressed by Fred, and I hope that you will not hesitate to reach out if you have any questions. So Fred, I'll let you take it away.
Thank you, David. I have a question in the chat box that someone is having difficulty hearing us. If that remains true, please let me know and we can figure out how to correct that. As David mentioned, I'm Fred Dawkins. I'm of counsel to Hall Benefits Law. My experience consists of representing businesses in employment-related disputes and also providing general employment-related counseling. That encompasses everything from onboarding and recruiting to performance management and discipline to terminations and separations and post-employment matters such as an EEOC charge, which we'll be talking about today, but also litigation related to other aspects of the employment relationship, non-compete, covenants, enforcement of those, and negotiation of separation agreements. So today we're going to talk about the EEOC process, and to keep things moving most efficiently, I'm going to turn off my video and we'll just dive right in. What we're going to talk about today are 4 different areas related to the EEOC charge process. The first is, what does the process consist of? you may have some general familiarity with the process and responding to EEOC charge, but I want to dive into it more deeply. I'm trying to make sure that folks can hear, and if you are having difficulty, please let me know so that I can advise the folks and go to webinar and we can get that corrected. So we'll talk about the mechanics of the EEOC charge process, what happens and how it evolves. We'll then talk about steps you can take as an employer to best manage that process. As part of the EEOC charge process, the EEOC may request to do an on-site investigation. So we'll talk about what that would look like and how you can best position yourself if you do have to deal with an on-site investigation. And finally, we'll talk about litigation. Most of these, or many EEOC charges end in litigation, and we'll talk today about how you can do things during the charge process to best position yourself for litigation. The first step in the EEOC charge process is when the employee believes that they have been treated unfairly or unlawfully, and they contact the EEOC to see what remedies might be available to them. Now, the EEOC has a specific set of laws that they're responsible for enforcing, but someone who thinks they've been treated unfairly at work may not know that when they make the initial contact. Additionally, a lot of employees may not appreciate the distinction between something that is unlawful and something that is, in their view, unfair. Just because something may be perceived as being unfair does not mean that it's unlawful, but it may motivate someone to seek some kind of relief outside of the company if they don't feel like they have an adequate resource within the company. So the employee contacts the EEOC, and one of the first things the EEOC will ask them to do is to complete what's called an intake questionnaire. That document requests that the individual provide in narrative form what exactly has happened with their employer and why that individual believes that the action may violate the law. After the intake questionnaire is completed, the EEOC will interview the person and ask any follow-up questions that may grow out of the intake questionnaire. If after completing that intake process, the EEOC investigator believes that there is sufficient basis to move forward, they will reduce that complaint into a charge of discrimination. The agency, the EEOC's focus over the last few years has been mostly on those complaints which implicate multiple employees. For example, if an individual comes forward with a complaint that their disability has not been appropriately accommodated, the EEOC will be interested in finding out whether the employer's process has resulted in other employees feeling as though their disability-related rights have not been fully protected. When the employee contacts the EEOC and they have the interview and the intake questionnaire, the EEOC is only getting one side of the story. Naturally, the individual who goes to the EEOC is going to tell their story in a way that makes them look most favorable. There's nothing really you can do about it at that part of the process because you really don't know that the EEOC has been contacted or what specifics they may or may not have been told. Additionally, the EEOC may, with the individual's urging, contact other employees and ask for their feedback regarding this individual's allegations. And those contacts may occur without you knowing that they have occurred. Once all of those information gathering steps are completed, the EEOC will reduce, and again, if they believe that the allegations suggest that the law may be violated, then they'll reduce the complaint to a charge of discrimination. the EEOC will then send to the employer a notice of charge of discrimination. And sometimes the notice does not require that the employer submit a response at that time. If you get such a notice, even though you do not have to submit a formal response to the EEOC, you should use that notice as a prompt to initiate the kind of proactive measures that we're going to talk about today. A very common question that I get from clients when they are faced with an EEOC matter and we get through the matter is, how can we avoid this happening in the future? And I have to tell them, unfortunately, that you can't avoid it. You can do everything perfect from an HR perspective. You can have the best policies in place. You can be very transparent with the employee about what is expected of them and when they're not meeting expectations. You can do everything to try to give them opportunities to correct whatever deficiencies exist. You can do all of those things and you still may get sued. If you own a business, unfortunately, it's not a question of if you will get sued or if you'll get an EEOC charge. It's a question of when. So you can't avoid it no matter what you do. And I encourage my clients not to feel as though they did something wrong simply because a charge of discrimination has been filed against them. The best strategy you can use, though, when dealing with that possibility, is to have sound compliance processes. That is, have a very clearly articulated anti-discrimination and anti-harassment policy, to have a very clear non-retaliation policy, and when you get complaints through one of those mechanisms, to conduct the most comprehensive investigation that you can and to take remedial measures when they're required. And you cannot control if an employee, despite all of your best efforts, makes a claim against you, but you can control how you can defend those actions and how you can demonstrate to a third party that your actions were above board. When you get the EEOC charge from the agency, the first thing that you should do is identify specifically what adverse employment action is being alleged. Failure to hire, unlawful discipline, promotion claim, or termination or retaliation. When you suss out what actions are being called into question, identify what employees had anything to do with those actions and what departments were involved in implementing those actions or taking the actions. Then ask and determine what documents and records exist which may recreate your actions and demonstrate that what you did was above board. Those steps are part of your obligation and your charge, no pun intended, to preserve evidence. You should take immediate steps when you get an EEOC charge, regardless of whether you're required to respond to the charge at that time, to preserve all of the items which are potentially relevant to the claim being made. One of the mechanisms to do that is to issue what's called a hold notice, which I'll talk more about in just a minute, but also review your record retention policies. If you have an email policy whereby emails are automatically deleted after 30, 45, 60, or 90 days, you may want to take some measure to make sure that any potentially relevant emails aren't inadvertently deleted. Likewise, think about items that current or former employees may have and third parties may have that speak to the situation in question. A hold notice is pretty much what it sounds like. It's an instruction, it's a written instruction to all employees to gather and preserve items relevant to the claims being made. The hold notice, and there's specific language that I use with my clients, it spells out very directly and very comprehensively what is encompassed within the hold notice. Among the things that it that it requires employees to preserve are hard copy documents. That would include desk files that supervisors may maintain separate and apart from what they maintain on their computer. Any emails or other electronic records that exist within the company's IP framework, and items such as text messages and so forth that exist on company provided devices. And to the extent that your employees use their personal devices, the hold notice should encompass those things as well. With respect to some electronic items, such as text messages, you may need to contact the appropriate service provider to make sure that you capture all of the potentially relevant items. I had a case that just concluded where text messages between an individual and their supervisor had some relevant exchanges. It was a sexual harassment case. And because some time had passed between the incidents in question and when the EEOC process unfolded, the individual said that they no longer had all of the text messages, that they had changed their phone. Well, when you learn of a potential claim, I would suggest that you immediately figure out how you can make sure that text messages and other electronic records aren't lost because someone either did not take any steps to preserve them or they changed providers or something along those lines. In the situation I described, there was going to be a mid four-figure dollar amount to recreate and capture those text messages. So if you take some steps on the front end, that may be an expense that can be avoided. Another thing that I would recommend that you do when gathering information that may be relevant to help you defend a charge of discrimination is not to just leave it to your employees to gather the items and hold on to them until they're requested. You should designate an employee within the organization to act as the point person, to follow up with everyone, to make sure that they gathered the information that's requested, to receive that information, and to secure it in some way. If you have employment counsel already involved, I would consult with them about what steps you should take to make sure that you're maintaining the information and you have access to it as the process continues. Your communications with your attorney about what documents you're gathering and so forth are shielded from disclosure because they're attorney-client privileged communications. However, if it's a discussion about what we're doing to gather information just between two employees, it's probably not going to be protected. And that means that it might be discoverable if the case goes all the way on to litigation. In managing the process internally, it may be useful to talk to your employees about what their rights are with respect to the investigation and the process. The EEOC, at least at the charge stage, cannot force any employee to talk to them. Now, as the situation moves on, if it goes to litigation, then subpoenas are a vehicle to secure someone's testimony. But at the charge stage, at least in the 30 years I've been doing this, I'm not familiar with a situation where the EEOC has tried to subpoena someone to talk to them during their investigation. If the individual who brought the claim, the charging party, if they're represented by an attorney, that attorney does not have the right to talk to employees without their consent. Likewise, as the employer, you can't forbid your employees from talking to either the individual who brought the claim, their attorney, or the EEOC. One of the reasons that you can't do that is because the National Labor Relations Act, which applies to unionized workforces primarily, offers protection for workers who are engaged in concerted activities. And that includes discussions about workplace conditions. So if you do forbid employees from talking about these kinds of things, you may inadvertently back your way into a National Labor Relations Act unfair labor practice charge. And those NLRA concerted activities, unfair labor practice charges are not limited to those companies that have union workforces. Even if you don't have a union workforce, your employees do have some rights under the National Labor Relations Act, and this is one of them. What I advise my clients to do when they're in the middle of one of these EEOC situations is to tell their employees that they have three options. First, you can, if you choose to, you can speak to the EEOC or to this individual's attorney. Second, you can decline to speak to them. Or third, you can tell them, I will speak to you, but only if the company's lawyer is a part of that communication and that conversation. Now, each situation is going to be different, but I think there's some benefit to telling employees what their options are. Number one, you might get some sense of whether or not they're going to be supportive of the individual who brought the claim. But the second, and I think the larger benefit, is that the employee who may be contacted doesn't feel as though they're kind of being left alone. You're giving them some tools to navigate this situation, and so you're helping them, and that may accrue to your benefit as the process and as if things move forward. When it comes to talking to individual employees, if it's someone who's not a supervisor or a management level employee, and they choose to speak to the EEOC or the charging party's attorney, then that's their choice. For a management level employee, however, neither the EEOC nor the charging party's attorney can speak to them directly. They have to go through the attorney representing the company or through some other official channel. They can't just call the manager and ask to speak with them. The reason for that is that the testimony of a management level employee can bind an employer. Their testimony about an employer's practices or something with a situation can be used as an admission against that employer. So for example, if the EEOC contacted a management person and said, Fred has brought a claim of age discrimination, and then that management level employee said, well, yeah, we were glad to get rid of Fred because he's too old for our workforce, then that testimony could be used as an admission against the employer. Now, there's some ways to challenge that because it's a management level employee and they're not supposed to have that contact. But that's just an illustration of how the management level employee's testimony can be used to bind the employer to that position. In situations where the individual who's brought the claim of discrimination is a management level employee, it gets a little more tricky to try to manage that. One tool you can use to try to do so is if you have a confidentiality or non-disclosure agreement in place. When I draft a confidentiality or non-disclosure agreement for my clients, included within the definition of confidential information is information about the company's personnel matters, business practices, vendor relationships, those kinds of things. So if the management level employee, just to use a hypothetical, is bringing a claim that their compensation is less than it should be, and that difference in compensation is based on age, if they, because of their management level status, access compensation information about other employees that they don't have a business need to access, then that may be a violation of the confidentiality agreement that they've signed. And there may be some recourse you can take to address the violation of the confidentiality agreement. So there are some tools that you may be able to use, but it's a little more dicey, not dicey, but it just takes a little more deliberation in how you try to do it. Other things that you might want to consider when you're gathering information to help you respond to an EEOC charge. Everyone has a computer for work purposes, I'm assuming, and it may be necessary to capture information on that employee's computer to access at a later time. Cloning someone's hard drive may be an easy way to make sure that you've got the information captured, but they can still go and use their computer to carry out whatever their work duties are. Other things that you might consider: do you have an existing policy on, for example, saving internet browsing histories? Whatever your policies are on use of the company's electronic data resources, those may be some avenues and some steps and some tools you can use to assist you in the information gathering process. And to the extent that you have not updated your electronic data resources policy recently, I think it's something that you should consider doing on at least an annual basis. So you've captured the information regarding this employee's claim of discrimination. You've got the hold notice in place. So what do you do then? What I try to do when I prepare a position statement for a client, and that's the name of the document where you respond to the employee's allegations. What I do when I create a position statement is to try to tell a story. The charge of discrimination is going to be maybe a couple of paragraphs where the person says, I work for this company, I was discriminated against because of my age, that discrimination violates Title VII of the Civil Rights Act, and I want relief. When I respond to that kind of a charge of discrimination, I don't limit myself to just addressing the bare bones allegations of the charge. What I do is I try to tell a story. Using the example that I mentioned earlier, if I worked for a company and was terminated and claimed that it was age discrimination, went to the EEOC, filed a charge, and they sent it to the employer. If I was the employer, I wouldn't just say, no, Fred was terminated because he had performance deficiencies that were never corrected. So this claim of discrimination has no merit. What I do is I would tell the story. Fred applied for a position that we posted in our marketing department. In that posting for the job, we identified that the successful candidate would have to, their job duties would include A, B, and C. Fred was selected as a result of the interview process, and Steve was the manager who made the hiring decision. When Fred was brought on board, Steve met with him, reviewed Fred's job duties, and gave Fred a copy of our employee handbook. In that handbook, our company outlines our policies against discrimination and harassment, our complaint mechanisms, and our commitment to prevent retaliation if someone comes forward with a good faith complaint. 3 weeks into Fred's tenure at the company, Steve began to notice some performance issues. Steve was receiving complaints from clients about Fred's performance, and for that reason, Steve met with Fred, shared those complaints with him, and gave him an oral counseling about how to correct those deficiencies. The deficiencies continued, and for that reason, 3 weeks later, Steve again met with Fred, reviewed the job duties and how Fred was not meeting the expectations, and placed Fred on a written warning. Despite the written warning, 1 month later, the deficiencies had not only gone away, they had become more pronounced. Steve was receiving more client complaints, and some of Fred's coworkers expressed frustration that his failure to carry out his job duties was impacting their ability to do their job. Because Fred had not corrected his performance deficiencies after being orally counseled and receiving a written warning, the company had no choice but to terminate his employment. Fred's aides played no role in any decision made regarding his employment, and for that reason, the charge of discrimination should be dismissed. In that story that I would lay out in the position statement, I've explained to the EEOC why these claims of discrimination have no merit. At the end of the narrative that I've put in my position statement, it's if I do it correctly, there's really not a need to address the specific elements of the charge, but I usually would do that anyway, just to be complete. So I'll tell the narrative, and then I'll say, as outlined and discussed above, Fred's charge of discrimination, of age discrimination, has no merit. But to address the specific allegations of the charge, here's our response. Fred was hired on August 2, 2021. Yes, he was hired in this position. These were his job duties as set forth in the job posting, as reviewed with him in orientation, and as reiterated during the oral counseling and in the written warning. Then the next element of the charge, as contained in the EEOC document, Fred was terminated on September 1, 2021. My response would be, yes, Fred was terminated on September 1, 2021 for failure to correct performance deficiencies. As described above, he was told about the job duties during his interview process and in the job posting. He was counseled about his deficiencies. He was given an opportunity to correct those deficiencies. And rather than correct those deficiencies, they became more pronounced. The next line from the EEOC charge, Fred was terminated because of his age in violation of the law. The response, as discussed above, the termination was due solely to Fred's inability to meet his performance goals, despite repeated efforts to correct those deficiencies and despite providing him several opportunities to correct those deficiencies. So after you tell the story and address the elements of the charge, the EEOC has your side of the story, and hopefully you'll get a favorable outcome. When you create your narrative, you have to make sure that you have support for the contentions that you make within that narrative. If a claim of discrimination goes to litigation, the plaintiff's lawyer will most often have your position statement and will use that throughout discovery, either in written interrogatories and document requests or in depositions. And they will ask you about the contentions that are contained within your position statement. So it needs to be accurate. So when you're drafting that position statement, or if your lawyer is drafting it, make sure that you're not saying something within that narrative that isn't true or is a little bit of an exaggeration. If you consult with counsel or work with counsel, your employment lawyer, in preparing that narrative, you can push back if they're kind of going too far or if they're not stating something as forcefully as you think is warranted given your factual scenario. To the extent that you're going to rely on witnesses within your narrative, within your position statement, make sure that you lock them down in some way, shape, or form. And this will depend on the case, on a case-by-case basis. Sometimes you may want to have those witnesses sign written statements. If that's the case, rather than you drafting the statement and having them sign it, I would prefer to have the employee themselves write the statement in their own words and sign it. Even if it's not grammatically perfect or they ramble on or something along those lines, the fact that it's in their own words makes it more compelling, I believe. If you're not going to create written statements or get signed statements from your witness employees, it's perfectly fine for whoever is working with the attorney, or if you're preparing the position statement yourself, to just create a memo to the file. I spoke with John regarding Fred's claim of age discrimination. John told me A, B, and C. I spoke with Susan regarding her interactions with Fred. Susan told me A, B, and C. I received complaints from these clients about Fred's performance, and having that somewhat contemporaneous document about what you use to prepare your position statement can be helpful, because number one, if it's created around the same time that the position statement is submitted, then when it's put in front of a judge or a jury 18 months later, then it has more credibility. Secondly, memories fade. And so over the course of 6, 12, 18 months, some of the specific details that may have informed your preparation of the position statement may fade. Those employees may no longer be there. And so if you've memorialized all of those things in some kind of form, a memoranda or getting written statements, then you're in a much better position. After you submit your position statement, recognize that the EEOC is going to show that position statement to the charging party, to the complaining individual. And if they're represented by a lawyer, to that lawyer. The EEOC will ask that individual, okay, you've made this claim of discrimination, Fred, that you were terminated because of your age, but your employer said that there were these performance deficiencies. How do you respond to that? The EEOC, after receiving the charging party's responses, may get back in touch with you with follow-up questions. They may also send you an RFI, a request for information. The request for information, at least the ones that I've received in the last few years, are a boilerplate document. It's not something that's specifically tailored to what your case is. It will include requests such as, identify all of your locations, how many employees do you have, what are your policies regarding discrimination and harassment. So it's going to, because it is something that the EEOC, in my experience, they just take the document and include it with their correspondence to the employer. It's not tailored to the parameters of your specific case, and so it's going to seek information that has nothing to do with the dispute that the EEOC is being asked to examine. What I do in those situations is I provide what's relevant to the specific claim. In the age discrimination hypothetical that I've been using so far, rather than talk about how many facilities the company has or anything along those lines, I will provide information about this specific termination, if there have been any other claims of age discrimination in the termination context within the last 2 or 3 years surrounding this specific charge of discrimination, and I'll provide that. The EEOC may push back against a limited response to a request for information, but if you provide what's relevant, they may not do that. But if they do push back and you've got an investigator who insists that you provide all of the information sought in the request for information, there are a couple of things you should bear in mind. The EEOC's remedy, if you say, no, I'm not going to provide these additional things, is to seek those things through a subpoena. That EEOC investigator has to go to their supervisor and explain to that supervisor why your response to the request for information is deficient and why it makes sense to seek to enforce the subpoena. If they do choose to enforce the subpoena, they've got to go in front of a federal judge. And the judge, who has a lot of things on his or her docket to deal with, they're going to want to know, okay, what is this about? Your Honor, we're seeking this additional information. And as the employer, you will have an opportunity to respond to the effort to enforce the subpoena. And you can tell the judge, Your Honor, this case is about a single age discrimination claim. We provided all the information surrounding that employee's termination and all their employment. And we also provided information about any age discrimination termination claim for the 3 years preceding this. So we believe we've provided the information that's relevant and potentially relevant to this claim. And the judge will most often ask the EEOC, why do you need anything beyond what they've already provided? And unless they have a good answer, the judge is not going to seek to enforce a subpoena. And it's not fun to go in front of a judge asking them to do something when you don't have a legitimate basis to do that. So the investigator and their supervisor will have to go through that analysis and figure out, is this really worth going in front of a federal judge to get this additional information? In addition to the initial position statement and perhaps some additional follow-up questions and a request for information, during the EEOC charge process, they may ask to do an on-site investigation. What an on-site investigation is, they'll come to your facility to do an inspection and to tour the facility. it doesn't happen that much in the harassment context. But for example, if it's a disability discrimination claim, if an employee has brought a claim that their workstation was not modified appropriately to address their disability, or for some reason they're not able to access an area of the facility, then the EEOC may come and say, okay, we'd like to see this employee's workstation. We'd like to see the areas that they're not able to access and see what other methods of access might be available to them. And they're allowed, the EEOC is allowed to do that under the statutes and under the law. When you get a request to do an on-site investigation, you should give some thought to who will take the EEOC investigator around the facility. Now, there are two ways to approach this. The first is to have someone who is familiar with the contours of the charge of discrimination to walk the EEOC investigator through the facility. The second option is to have someone who knows absolutely nothing about the charge of discrimination and just instruct that person in the second scenario, okay, the EEOC is here to do an investigation, show them these areas, and then bring them back. The advantage to having someone with no familiarity about the contours of the charge of discrimination lead the tour of the facility is that the EEOC investigator, if they are inclined to just ask some questions kind of in a casual way, say, hey, is it unusual for, what kind of employee was Fred? Did he tend to complain about things, or did he perform pretty good? Did you hear any complaints about him? If the individual conducting the tour has no familiarity with Fred's age discrimination complaint, then they don't have the ability to answer those questions, and they can say, I don't know, I didn't work with Fred, I'm just, giving you this tour of the facility. If the person conducting the tour is familiar with the contours of the allegation of discrimination, then they can just say, you need to direct those questions to our attorney. During the on-site investigation, the EEOC can also request to conduct employee interviews. Before the on-site takes place, you can tell your employees, okay, the EEOC is doing this on-site investigation. They may want to interview you as part of that investigation. Here are some things that you can expect. You can't tell your employee, if the EEOC wants to interview you, you can't participate. You shouldn't participate. That decision, if you give that kind of direction to your employee, then it'll create other difficulties, and it's just not something that I would advise in any circumstance. You have a limited ability to observe those interviews. If it's a non-management level employee, the EEOC has the ability to go into a room and talk to that person one-on-one without anyone from the company being present during that interview. To the extent that you have an on-site investigation and the EEOC does employee interviews of non-management personnel, you should think about interviewing those folks afterwards. What did the EEOC ask you about? And just get a sense of what the EEOC was told, and if they're trying to expand their investigation and the charge beyond just the allegations of the individual employee. After the EEOC does the on-site investigation and has completed all of the other things that we've talked about, the position statement, any follow-up questions, the request for information, they will issue a determination. The two options when they conclude their process and make a determination are what are called within this space either a cause or a no cause finding. The actual language that the EEOC uses in its letters is, we were unable to conclude that the evidence establishes that the statute was violated, or we were able to conclude that the evidence establishes that the statute was violated. Regardless of whether they make a cause or a no cause finding, that determination has no impact on what happens if the case goes to litigation. The plaintiff can't use that to say, hey, the EEOC found that I was discriminated against, so Your Honor or jury, you need to find on my behalf. They can't do that. Likewise, the employer can't use a no cause finding to say, hey, jury, or hey, judge, the EEOC found that there was no basis for this, so you should throw this claim out. What the cause or no cause finding may do, however, is either incent an attorney to take the case on or discourage it from taking the case on. If the EEOC has found no cause, an attorney is going to be less likely to take that case on and expend their resources trying to prosecute what may be a losing case. In addition to setting forth what the EEOC's determination is, that cause or no cause letter includes a statement of their right, the individual's right to sue. Regardless of what the finding is, the individual has a right to, within a certain time frame, bring a lawsuit to seek to vindicate their rights if they think that the EEOC got it wrong, for example. One thing that I did not mention before, when you're preparing your position statement, when you first get the charge of discrimination, it'll have the individual, the charging party, who believes something was done wrong to them. It may also include the name of an attorney who's engaged to represent that individual. In that situation, and again, it's on a case-by-case basis, you may want to provide a very skeletal response to the charge of discrimination. The reason is that if there's an attorney involved from the very beginning, it's likely that they're going to file a lawsuit no matter what happens during the EEOC process. And to the extent you provide information as a response to the charge of discrimination, you're giving that plaintiff's attorney a preview of your defense of the case and what you're going to use to defend the allegations. That may not make a difference at the end of the day, but if you know from the very beginning that the employee and their attorney are just going through the EEOC process because that's something they have to do before they can file their lawsuit. There have been situations during my career when I've encouraged clients, let's do the bare minimum here because we're going to be in litigation and we don't need to tip our hand any earlier than necessary. When the lawsuit is filed by an attorney, that's a private action, and there's a different set of, not a different set, but there are some remedies that are available to a successful plaintiff who goes through litigation than if the lawsuit is brought by the EEOC. If it's brought by a private attorney, they may be entitled to recover their attorney's fees if they go all the way through and win the lawsuit. If the action is brought by the EEOC and they do sue on behalf of individuals, then they can't recover their attorney's fees. They're government employees, so their attorney's fees have been paid all throughout the case because they get their government salary. But there are different strategic objectives if the action is brought by the EEOC as opposed to it's brought by a private attorney. And the litigation, in my experience, looks different sometimes when it's a private attorney or an EEOC. The EEOC, as I mentioned before, is focused more on actions and practices that affect more than one employee. So that's what they're going to be more inclined to devote their resources towards. Another difference between a lawsuit that's prosecuted by a private attorney and one by the EEOC is that a private attorney has to make decisions about how they're going to prosecute the case and what resources they're going to use to do so. Taking a deposition can take anywhere from 2 hours to 8 hours. And the court reporter expense associated with that can be from $700 up to $4,000 or $5,000. So a private attorney is going to have to do a cost benefit analysis. Do I want to take 10 depositions and spend $50,000 getting sworn testimony, or can I move my case forward just by taking 2 or 3 depositions? The EEOC doesn't have that governor in place. So they may be inclined to take as many depositions as they think are potentially relevant. I had a case once where the EEOC is the plaintiff and they took about 16 depositions. They had to get the court's permission to take those additional depositions, but they clearly were not constrained by the cost that was associated with taking so many depositions. So there are different strategic objectives if the action, the lawsuit that is brought by a private attorney as opposed to the EEOC. Just something to bear in mind. Once you get into the litigation context, what I do with my clients is issue a second hold notice. This is termed a litigation hold rather than an EEOC charge hold. It does the same thing. It asks for the same information, but since we're in a different framework now, it's useful to make sure that any potentially helpful or relevant information doesn't fall through the cracks. To the extent that you have employees, current employees or former employees who are going to be witnesses, you should weigh whether or not you want to memorialize their recollections and so forth in written form. And if you are in a litigation context and you've engaged counsel, if an attorney interviews employees and procures statements from them, there's case law that those statements are attorney-client work product because they reflect the strategic thoughts of the attorney, so they can be shielded from disclosure until the summary judgment stage. So there's some considerations to bear in mind there. I think it's definitely worth considering because, as I mentioned, individuals may not have the same recall at the beginning of a case being filed as they in 12 months or 15 months down the line. So those are the things that I would encourage everyone to bear in mind as you deal with an EEOC charge. There are a couple of questions that came in that I'll go ahead and address now. So how would you recommend, the question is, how would you recommend responding to the EEOC or the state equivalent agency request for notes and documentation on an internal investigation conducted by an attorney? Well, those documents are attorney-client privilege or work product documents. So on the one hand, they are entitled to protection. However, if you're going to rely on your investigation as a way to defend the claim, then you may need to figure out a way to provide some information about what your investigation was. But I don't think that response should include the attorney's notes, things of those nature. Documents that the attorney reviewed or that were provided to the attorney in connection with the investigation, perhaps, but definitely not notes that were created by the attorney. Second question, if the responding party does not receive a no-cause determination in over a year from the EEOC, should they follow up on it? Well, I don't think so, because the EEOC, as are many federal agencies, have limited resources. So it may take them quite a while to do an investigation. I had a situation where the EEOC started a charge and did an investigation, and we submitted the position statement, and we didn't hear from them for over a year. It wasn't because they felt like they didn't need to move the case forward. It was because they just didn't have the resources to do the investigation. And so I wouldn't recommend that you follow up with them on it. You can if you want to kind of see, kind of fish or cut bait kind of approach to it. But my personal view is that just let it lie, and the longer it goes, I think the less likely it is that it'll result in a cause finding, and that may be the end of it. Plus the amount of time that it takes, if it takes over a year for the EEOC to analyze everything and make their determination, the charging party may lose interest in pursuing the case. So that's another potential side benefit to just sitting back and waiting for the EEOC to conclude their process. And again, if you've already implemented your EEOC hold notice, you've secured all the information, you've got all the documents, you've got employee statements, either written statements that they did, or you've got something memorializing their comments, then the passage of time is not going to in any way impede your ability to defend yourself. So those are my observations on that. Another question, what document is vital to gather in all cases to be prepared if there is a charge for litigation? I think I've covered that to some extent during the presentation, but I would gather any documents related to the employment action that's at issue, to the extent that the situation involves interactions with a third party. Again, going back to the hypothetical I mentioned where Fred is claiming he was discriminated because he was terminated because of age discrimination, when in fact there were client complaints about his job performance, preserving those client complaints and so forth. That would be the kind of documentation that I would preserve. Basically anything that not only allows you to demonstrate that your actions were above board, but anything that just relates to the mechanics of Fred doing his job, what was expected of him, the counselings and so forth. If there are no further questions, we have about 3 minutes according to my clock. If you have questions after we conclude today, feel free to send them to me by email or call. Again, I appreciate the opportunity. Hope that we've covered some things today that will be helpful to you. And if you do need further information, that's the way to reach me. I also understand that the presentation, both the slides and the audio portion, will be made available to everyone after today, sometime in the next couple of days. If there aren't any further questions, I will turn things back over to Jordan and wish you all a good holiday weekend.
Fantastic. Thank you so much, Fred, for an excellent presentation. I'm sure our audience members will have learnt a lot from today's session. Just a quick reminder to those still in the audience, the session has been recorded, as Fred mentioned, and we'll be sharing a copy with you all via email in the coming days. If you do have any last minute questions, pop them in the questions box now and I'll ensure that they are sent over to Fred. Or additionally, you do have his contact details here on the screen. So all that's left to say is another huge thank you, Fred, for a very insightful session, and to all of our audience members for joining us today. We hope to see you all on another webinar soon. Take care, everyone. Bye-bye.